Hi, good afternoon, everyone. This is Rajiv Khanna from immigration.com, the law offices of Rajiv Khanna PC. This is our bi weekly community conference call, which we have every 2 weeks, every other Thursday. Today is July 27th, 2017. Let me begin. We have a short conference call today. Let me begin with the two questions I think are frequently asked questions. First one says, does H4 require a prior USCIS approval for visa stamping? So the question is this. Srinivas has an H1 visa and an I-94 which is valid till September 2017 with the previous employer. Now, he hasn't filed for H4 for his dependents as he moved to employer B, and they are traveling to India. Now, his approval with employer B is good till 2019. The answer to your question, do I need to get H4 extension from the USCIS? The answer is no, because when you have certain derivative visas like H4, L2, you don't need a separate approval on the derivative visa from the USCIS. Those visas are given based upon the approval of the H1 holder, the L1 holder. Now, can you use the Dropbox facility? That you have to look at the local rules. I don't know all the local rules off the top of my head. Whatever the rules say, you follow those. But as far as getting an H4 extension, prior to getting a visa stamping for your derivative beneficiaries, your spouse, your children, that is not necessary. *5 if you have a follow-up question. Anybody has a follow-up question on this? Press *5. Okay. The next frequently asked question is, this is also asked quite a lot. Let's say I'm working for employer X, and this is from Anand Brahmbhat. Let's say I'm working for employer X and my green card is going on through them. I filed a 485. I've got my EAD. Can I have a second job? Can I have a third job? Can I do 4 jobs at the same time? And the answer to all of this is yes, as long as you have one job. If you qualify under AC-21, that is same or similar to the offered job under the green card, or if you are going through the green card sponsoring employer, you will maintain that job. So if you are currently maintaining that job full time and doing all other jobs at the same time, or you intend to return back to that job when your green card is approved, you can actually have simultaneous jobs in several different with several different employers. I always tell this story that we had a client at one time who had 4 full-time jobs. It was either 3 or 4. I think it was 4 full-time jobs. And the reason he could do that was because he was a database administrator who was on call with 4 different companies. One company was the prime sponsor, but 3 other companies were also paying him full-time salary just to be on call for 24 hours each day. Of course, he rarely ever had to go in, but if there was any kind of troubleshooting necessary, he went in and he took care of it. So you can have more than one job. Is it important to have a continued pay stub from employer A? This is a little tricky question. So you see, green card is based upon a job offer which could be present or future. So if you're working for employer A, it can be a job offer for a present job, or they could be offering you a promoted position. You're working as a systems analyst, and when you get your green card, you will be promoted to project manager, for example. You can have those situations. The essence of a green card is that you will either join the job upon approval of the green card, or you're already doing it. And of course, along with that comes AC-21, which says, oh, not only can you join back or keep doing the same job, after 180 days of 485 pendency I-140 approval, you can actually get a same or similar job anywhere. So there are a lot of different permutation combinations you can take advantage of, take help from, but it is very difficult to pin down the exact circumstances of everybody's case. I strongly recommend, these are important issues, don't depend upon our generic statements. Have your case looked at. But generally speaking, you can work for another employer for a few months and then come back to employer A. The only question is, if you are already working for employer A, and I've raised this before, and you have a permanent job, number one, why are you leaving? And two, if you're leaving, who is doing that job in your absence? As long as you have good answers to these questions, and as I said, strongly recommend that you please get a consultation from your own lawyers or a third-party lawyer if you don't have access to your own lawyers. Get an opinion, make sure they go over your case in your unique circumstances. But all of this is possible. Star 5 if you have a follow-up question, star 5. Okay, there's one. Columbus, Ohio. Go ahead, please. Ohio. Ohio, we can hear you. Hello. Are you on mute on your side? Because, yeah, go ahead. Go ahead.
So can you, so while working with an employer B, does the employer B need to file the AC-21?
Not if you don't intend to get your green card through employer B. So if your intention is to go back to employer A and you have an EAD, there is no requirement that employer B, C, D, or E, whoever else you work with, file an AC-21 supplement J for you. Okay.
So, but if it is filed, then I cannot go back to employer A.
Well, supplement J does not stop you from going back. I don't see it as like that at all. You always have the option to go back. I don't see any problem with that.
Okay. So will employer A find out that if a person is working with employer B and still continuing with employer A?
I don't think that employer A can find out, at least not from US immigration. You have a privacy protection. If an error is made by the government or they find out through some other agency, which I can't think how that could be, but normally the employer A should not be able to find out that you're doing two jobs at the same time. Okay?
Okay. And if there is no paycheck from employer A?
Yeah, I've already addressed that. I've already addressed that issue, because then you have two problems. One is, if you had a permanent job, why did you leave? And two, if there was a permanent job, who is doing it in your absence? So when you don't have pay stubs, these two issues can be raised. I won't say that they have been raised, but they can be raised. And I've had that come up once in almost 30 years of my practice. Okay?
Okay. Can this be done just for like few months? Like for 3-4 months and go back to employer A?
The same issue. Why are you leaving if you have a permanent job? Who's doing your job? Okay. Ma'am, I gotta go on. I've got other questions to deal with, okay? Good luck. Okay, folks, you have to really be decisive and quick about your questions. Let's go back to the first question, which is non-frequently asked question. Now, this is about adoption from India. And what they were planning to do was, they are on green card. They wanted to go back to India and take custody of a child that has been adopted locally in India and bring her back under a provision of law that allows you to take physical custody of a child and bring them back as your own child. So there are some very specific questions, and Amitji, I'm not sure I have the answers for you because I have to look at the law. Does the 2-year time period begin from the foster care agreement start date or actual court order date? I don't know the answer to that question. See, I'll have to look at the procedures. It very well could be that when the court order is given, it says that the adoption became effective from the foster care agreement. Normally, foster care is not adoption. So I really don't know what the local court procedures are. Whichever date your adoption is considered to be formally completed on, even if it is applied retroactively by the court, that would be the date the 2 years begin, in my opinion. I haven't looked up the law. We are thinking of applying for re-entry permit extension for one more time. And I know we might have to visit again in the US for doing that. Would you know if we apply for re-entry permit, I'll be able to get 2-year extension? You might be able to, it is difficult to predict. I have seen government keep on giving 2-year extensions even on second or third extension. They are supposed to technically drop down to 1 year, but they've been doing it for 2 years. Would you know if we apply for re-entry permit, will I be able to get a 2-year extension? Okay. Will I be able to apply a business visa for my second daughter so that she could also travel? You can get a tourist visa for her. I don't think that should be an issue. Okay. Star 5 if you have a follow-up question. Amit, if you're on the phone, star 5. Okay, let's go on to the next question. There is a massive EB3 movement, and it's very difficult to extrapolate just from 3 months data or 4 months data how dates are going to move. If my company put an H-1B extension request to USCIS in November 2017, will USCIS provide me 1-year extension? Well, in order for you to get 3-year extension, as I remember, the dates have to be backed up, priority dates have to be unavailable, not only on the date you filed the H-1 3-year extension, but also on the date it was adjudicated. If either on the date you filed or on the date it was adjudicated, your priority date becomes current, you will get 1-year extension. Will I keep getting my H-1 extension in the future too, even if my priority date becomes current? I believe so. 1-year extension should be available all the way through the actual receipt of the actual approval of the green card. Star 5 if you have a follow-up question on this. Star 5. Okay. H4 travel to the US while H1B transfer is in progress. This is from Chandra. I have an H1B visa. My spouse has an H4 stamp which is good till December 2019. In the meantime, I'm starting my transfer. Can my spouse travel to US based upon my H1B receipt for my new employer? Absolutely. Absolutely. There is no requirement that H4 visa is tied into your old employer. As long as you are maintaining status, the H4 holder can travel into and out of US, no problem. Star 5 if you have a follow-up question. Star 5. Okay. Next question is about political asylum EADs. No clue about that. I'm sorry. We don't practice in that area. So my knowledge is very limited, but I can tell you this. The normal deadline that the government seeks to achieve for all pending applications is 6 months or less. Are they actually able to meet it? I don't know. That depends upon their workload. But I do not have specific knowledge about asylum laws or processes. Next question is also from Anand. I'm not sure I can answer these questions very effectively. You have a whole bunch of them. I think you need to do a one-on-one consultation with a lawyer, but I'll try to answer as many as I can. Can I work for a new employer using EAD without filing anything with the new employer? Yes, you can. Can I go back to the old employer? I've discussed this in detail. Can new employer file H-1B on old approval I-140? Yes, they can. Is it a brand new H-1B since the old H-1B was not renewed? Doesn't matter what you call it. They can get you a 3-year extension You will have to go outside USA to get visa stamping if there is a gap between your H1s and you were only maintaining your legal stay in the United States because of the 485. So you will have to go outside for visa stamping. And you can do that anytime after the approval, 10 days after the approval or 10 months after the approval. Go get a visa stamp. In the meantime, you can continue working with your EAD. Is it safe to work on EAD? Okay, spouse name is misspelled on I-140. The name is accurate on 485. I think you should be okay. You can call USCIS and just alert them to that fact. I don't think that should be a problem. Is it safe to work on EAD with new employer by filing supplement J? Is anything else required to be filed? Yeah, if you want to do an AC-21 transfer over to a new employer with the same or similar job, that is the key. If the jobs are same or similar, there's nothing else that you need to do. How to identify or calculate SOC? That's a long topic. Any tentative idea about when the dates will become current? No idea. So as far as identifying the SOC code, remember it's same or similar. USCIS has put out a couple of opinion letters on this. You can review those, but I suggest you stick with a lawyer on that. *5 if you have a follow-up question. *5. Go ahead. Ohio.
So for the H1B, is it like I need to wait until next year, or it can be done anytime?
You are not subject to the quota if your H1 was approved anytime within the last 6 years. Okay?
Oh, okay.
All right. Anything else?
No.
Good luck. Okay. Next question is, now this is a little bit complicated. I'm not sure whether you've got the sections of the law right, because there's a typo in the section that you have given me. It says 212A7 A, then Roman numeral small 1, Roman numeral small 1. That's not a section. There's no such section. If you mean Arabic numeral 1 and Roman numeral small 1, that is communicable diseases. If somebody has been turned away at the airport because they had a communicable disease, there are several ways that can be handled, including getting, excuse me for a second, including getting certain procedures done with the Center for Disease Control showing that the person is being treated and they are no longer contagious. So I don't know if that's what you're asking me. Are you on the phone? Press *5 if you're here. Okay, so I really don't know exactly what happened here. Since he had to wait at the airport, can this be considered detention? Look, I'm always of the opinion to over disclose. When you file the N-400, disclose it, because it will be covered as one of the arrested, detained, charged, indicted, fined. I would just say yes. Are you convicted of a crime, offense, or committed? No, I think you can just say no to all of those, unless you're talking about 212A7, A1, or is it A2, which is fraud. That's a different ground altogether, and that's usually a permanent bar from entering the United States. I can't help you fill the forms, but I can tell you this is not a crime, but you should reveal it anyway, so that government can't come back and say you tried to conceal information that was important to the case. Okay, but if it has gone through all the way to green card earlier, it doesn't look like it should become a problem for him. *5 if you're on the phone. Okay, next question is from Charan, who says, my realtor would like to give me back a part of his commission on 1099 because I'm buying real estate through him. Is it legal? I'm on H1B, and I think it's legal. I don't see any problem with it, because this is not income based upon any activity you've done. My guess, I have no way of knowing if I'm right, but my guess would be income that you have generated by passive activity, somebody is giving you back money because you bought real estate through them, I don't think that should be a problem. It should neither affect your H1 nor your green card. That would be my best educated guess. Star 5 if you have a follow-up question. Star 5. Okay. Next question is Imi Kumar says, question regarding H1B with I-140 approved and employer layoff. I have an I-140 approved more than 6 months. Priority date is March 2011 under EB2. If my current employer lays me off, what steps do I need to do to legally stay in the US? You've got that 60-day grace period to apply for another H1, and you already know that you can apply for a tourist visa at least to get you a few months stay in the United States. Okay. Say for example, after 90 days I get a job. I won't have pay slips. You will have to go outside USA for visa stamping. Chances are USCIS is not gonna give you status within the United States if you have gone over the grace period. You can try, but I think it's unlikely. Again, a matter to be discussed in detail with your lawyers. Star 5, if you have a follow-up question, star 5. All right, folks. Okay, there is a question. Pennsylvania, go ahead, please, Pennsylvania.
Hey, Rajiv. Afternoon. I got your answer. So looks like if this is the case, then even if I get a job, then I need to go back to India and then get stamping or anywhere else outside the country.
Right. If USCIS declines to give you status, you will have to go outside USA for visa stamping, but also be mindful of something called unlawful presence. Being out of status is merely a small issue. Being unlawfully present becomes a major issue after 180 days and even more major after 1 year. So unlawful presence can, I tell people, rule of thumb, think of unlawful presence beginning on the date you get laid off. Why? Because chances are the employer will try to revoke the I-94, revoke the status effective the date you quit working. And there is some gray areas there. Does that really start your unlawful presence? I would say yes, it does. Let's not take a chance with that. So within 180 days of when you stop working, try to leave the United States if you have not received a job offer and have not had a detailed discussion about your situation with a lawyer. Okay?
Okay, so after 90 days, for example, if I get a job, then can I do my H1 transfer and file the receipt and then start working?
I don't believe so, because you are not maintaining status. There is a very weird opinion some years back from, I think it was Nebraska or Vermont Center, which said in a very narrow set of circumstances, even though you are out of status, if your I-94 is still valid, you could start working. But have your lawyers look into it. There may be a possibility if your I-94 has not yet expired. But have your lawyers double check it. There's a very odd little opinion which I always am very hesitant to follow unless I'm being really aggressive. So generically speaking, no. In your circumstances, if the I-94 has not expired, worth looking into once. Okay?
Okay. Also, I have another question I wanted to post in the last forum, but somehow my question did not get through. Can I ask one more?
Yeah, go ahead.
This is also the same last week follow-up. Actually, the compiling circumstances EAD for the 140 regulations.
Mm-hmm.
Actually, I look into your chart, and then looks like in case if I am got laid off, I believe that there is some 3 cases, circumstances that will apply for me.
Sure.
One looks like I just got a home ownership. I got a house last year. So looks like that is one eligibility.
It could be.
The second one is, yes, if I laid off, then I will be financially, under harm. And then I am here for more than 11 years. So I cannot go back to India and uproot my family. So these three cases looks like favor to me. So do you think that this will help me to get compiling circumstances EAD in case if I laid off?
I just pulled the chart myself, and that's actually my go-to chart every time I want to double check it. So difficult situations outside the worker's control. Your I-140 must be approved. Priority dates are not current. Examples of compelling circumstances are serious illness or disability, for instance, requiring moving for medical treatment or change in working hours, employer's retaliation of some kind, harassment, etc., significant harm to worker, financial harm to worker or family. For example, somebody is laid off and their expertise cannot be used in home country. And I always give this example. We had a client from Pakistan who was a satellite engineer, and Pakistan doesn't have a satellite program. Return to home country creates total uprooting of the family. You could take that example. Reaching time limit on status is one of the factors, but not enough by itself. So I have actually pointed out all the factors, and if the more factors that apply to you, the greater are your chances of getting an EAD based upon compelling circumstances. You could try, sir.
Okay, so in your case, or any of your experiences, do you face any such case?
I think we have 3 compelling circumstances EADs filed right now. I don't have the results on any one of them yet.
Okay, so how long it takes, Rajiv, like for if you file for a EAD company?
This is so new. This is so new. We don't have any performance data on it yet.
Okay. All right. Okay. Thank you very much.
Oh, you're welcome. Good luck, sir.
Thank you.
You're welcome. There's another question from Ohio. Ohio, go ahead, please.
Hi, Rajiv. This is like from the prior question about H1B. So what if it has passed like more than 6 years of H1B and just using the EAD?
No, that's not the issue. That's not the issue. If, let me just take your case for example. When was the last time you were on H1 status?
Don't exactly remember, but it must be around 2011 or 12.
Okay. If it is 12, I don't think you have any problem getting an H1 outside the quota. If it is 11, your case should be reviewed by a lawyer to see if there is a chance to argue. So if it is within the last 6 years, you're okay. All right?
Gotcha. Okay.
Good luck.
Yeah. Thank you.
You're welcome. Okay. I think we've covered the questions that were posted. Folks, I can open the floor to any questions anybody has. *5 if you have any question whatsoever. *5 if you have any question. 1. Okay. All right. So that will be the last question of the day today. Let's go to Texas. Texas, go ahead, please.
Hello, good afternoon, Rajiv.
Good afternoon, sir.
Sir, I joined a bit late. Actually, this is IMI Help 2013, and the question Arman for that thing.
1 second. Oh yeah, I didn't quite understand. I wasn't sure. I'm not going to go over the whole thing all over again. Was it because of a contagious disease? Is that the reason for denial?
Sorry, what was the question, sir?
Why was he turned away at the airport? Was it because of contagious disease? Because I think that's the section you're referring.
No, actually, there was some kind of client, that.
So was it fraud or misrepresentation?
I I believe it was for like there's something called as client relationship, right, in H1B terminology.
Okay, no, wait. You see, there are a couple of things. I think the ground of denial is not clear. So I really don't know. What I hear you say is that USCIS or Customs and Border Protection was not convinced that the entry was for a genuine H1B occupation, correct?
Yes.
Okay. Now, that can go two ways. One is a very simple denial, or actually they allow you to withdraw your request for admission. Let's see, did they allow them to withdraw the request for admission? Yeah, they did. You said that in the very beginning. A friend of mine was allowed to withdraw H1B application voluntarily. So when they allow you to do that, that has no immigration consequences. Okay, as you know, he entered the USA on immigrant visa after marrying a US citizen. Now the question that you have, first of all, I cannot help you fill out forms, but I can tell you this, that this kind of an arrest or stoppage, you should just say that you were detained. I don't think that's a bad thing to do. But once you say you've been detained, yeah, yes, go ahead.
Sorry to interrupt you, but because in terms of legal terminology, what exactly does detain mean?
Well, I could talk about what detain means with considerable, for a long time, let's put it this way, because to detain means restricting your freedom to move. So if I tell you, sit here, don't move, that's detention. Okay? I don't have to handcuff you to detain you. I can, if I restrict your freedom to move, I can tell you, for example, you cannot go in these 3 directions, but you can move around in this room if you like. That's detention. Now, here is my, hang on, let me finish. Here is my advice to anybody who fills out any immigration form. When in doubt, you are better off disclosing everything that you have a doubt about. So if somebody says, have you ever been detained on any form? The answer is yes. Because if it turns out not to be true or not to be a problem, it is no issue. But if it turns out you did not disclose it and they find out and they think of it as a detention, they can create a lot of problems for you. So it's better to say yes.
No, they have, that case has been closed while facing the immigrant interview. The visa office had asked the questions related to that as well while facing the interview.
Sir, let me back you up a little bit. It doesn't matter what happened. It doesn't matter how the case was disposed of. Were you detained? Yes. Okay? I'll give you another example.
What about like a simple example for a cop pulling driving the person when a person is driving the car and
I don't think that's a detention. But if the cop says you have to follow me to the police station, that probably is detention. If the policeman issues you a citation, like a ticket, that I think is a citation. It should be disclosed. Although we've had a conversation with USCIS on this. USCIS has said even simple speeding tickets we don't really care about. You can disclose them even during the interview. I don't like that answer. I feel the question on the Form N400 includes the word citation in respect to that question. It should be disclosed. And sir, I can only give you my opinion. This is not God's word. In my opinion, if you were my client, I would disclose everything. Okay?
Okay. Rajiv is like a Department of Justice advocate representative, similar to be an attorney.
Department of Justice representative similar to an attorney? I don't know what that means.
No, they are some kind of accredited representatives, right? Those are being, certified by USCIS to like G28 form, right?
Oh, hang on. They are not lawyers. No. A lawyer, see, USCIS does not certify anybody. But there are agencies who help people without charge, and sometimes they can file a G28. They are definitely not lawyers. No, sir. Okay.
So using their help for filling out such forms is like kind of okay?
I know, in my opinion, no, sir. Not for a case where you have any issues and doubts. Simple forms anybody can fill out if you have no complications. But in order to know whether or not you have a complication, you have to know the law. Okay. I must move on. Do you have any other questions?
Not really, sir.
Okay.
Thank you.
You're welcome. You're welcome. Good luck. Okay, folks, we are constrained. We cannot help people fill out forms because if you look at the form, it says whoever helped you fill the form must sign it. And if we are helping you fill the forms, then we must sign them. And that means we are representing you. So we really cannot help you with the forms. Any other questions before we finish this call? *5 if you have any other questions. Okay, very good. Good talking with all of you. I'll see you again in 2 weeks. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.